What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And Bettero is back. We're going to talk about what is going on in Massachusetts. Why is Adam Lally on the stand in the King case? And what does he have to say to give us a little peek into what it's like in his office? In the Brian Walsh case, motions to suppress were partially granted by Brian Walsh's attorney based on some of the police work done by some very familiar names from the Karen Reed case. We also have the Sandra Birchmore case, which has all sorts of police wrongdoing in it. And then more news in Karen Reed's case that just makes you scratch your head and things that make you go, that we're going to ask Mark Bettero about right now. Mark, you're back. You're back. Karen Reed's over, but you're still here.
I'm still here, much to the chagrin of many people, I'm sure, but here I am.
Here you are. And you have some experience in Massachusetts and in those courtrooms and with some of these people. And so as I'm watching this unfold, and I'm thinking to myself, when I watched the Karen Reed case, I know you were kind of involved, then almost more involved, and practicing in that area. You're in New York, but have cases in Massachusetts, of course, as well. I was thinking Karen Reed's kind of a one-off, some bad apples, especially in law enforcement. And then the next bombshell to drop to me was the Sandra Birchmore case. But it just kind of feels like it's never ending in Massachusetts. Is Karen Reed a one-off, or do you think there's a real problem in that area?
I don't think it's a one-off. I mean, you saw it in her case. I think you've seen it to some extent in the case I'm dealing with, which I'm sure we won't talk about too much. You saw them, the way they handled Sandra Birchmore. You see some of it in this Brian Walsh case, and you see some pretty shocking stuff in this Miles King case. But it's not even just Massachusetts. I mean, you can narrow it even further. This is one county. There are several large counties in Massachusetts, different offices, and all of this is happening in Norfolk. And the question is, how is this possible? And it just leads you to question the leadership, training, and experience and competence in that office, both at the level of prosecutor and, of course, with the state police who were previously, anyway, embedded in there, who, though, appear one by one to be being jettisoned out of it.
Yeah, that's a whole other thing all on its own. But you mentioned it starts at the top and the training and how that office runs. And that brings us to that Miles King hearing where Adam Lally was literally on the stand, which is unusual. We don't usually get to question prosecutors about the way they handle their business, the way they keep their files. I mean, some of the questions that were allowed, I was kind of surprised at, but I was very interested to hear his answers. And then as you heard his answers, I can't say I was surprised based on the Karen Reed trial and the Karen Reed case and the arguments that Karen Reed's lawyers were making. But on the other hand, I was shocked for a very seasoned prosecutor to think that these answers were okay. And I'll give you some that stuck out to me, but I also want whatever you remember from it. But he doesn't keep a chart. He doesn't keep track of what he has and what he doesn't have. He doesn't always call them when they don't turn things over. He doesn't always press the issue even on very constitutionally protected discovery that you have to turn over to the defense. It's just kind of like, and months can go by and he doesn't really do anything else to make sure he does his job and get the information to the defense. Or even less than getting it to the defense as a prosecutor, don't you want that information so that you can properly evaluate the case and make decisions on what you're going to do and who you're going to prosecute? That was mind-boggling to me that he admitted that on the stand.
Yeah, I mean, there are so many things to unpack with all of this. You mentioned the mere fact that a prosecutor is testifying. Certainly in a pre-trial context, that's extraordinarily rare and probably never a good thing, as opposed to a post-conviction motion where there could be a hearing to decipher certain things. But having a discovery dispute that requires a prosecutor to testify pre-trial without more is in and of itself bizarre. It's just not a regular thing. You start talking about testimony involving basic level stuff, which is simply disclosing evidence which the state statutes require you to disclose. Certainly, if any of it's exculpatory, that has constitutional implications. And you're talking about, as you mentioned, a 20-year so-called experienced prosecutor who handles the most sensitive and important matters in the entire office. I mean, he was involved with two Karen Reed trials. He was involved in this other trial, which is just what appears to be an alleged street, literally in a very nice town, by the way. Milton, Massachusetts is a pretty nice town. Not something you would expect to see on a daily basis, that kind of crime there. And we're talking about the simple task of being aware and disclosing search warrants in a murder case. And for him to testify that he, over the course of 4 years plus, did not disclose search warrants of which he had actual knowledge and actual possession, custody, and control of for the better part of 4 years for a defendant who is incarcerated awaiting trial, and to testify in such a nonchalant, woe is me, don't really care, just complete indifference. It's the only word that really comes to mind is just absolute indifference. That I asked the state trooper Proctor, as it were. It's the same people as he said, the
Crazy to hear the names.
same cast of characters. I asked him for these search warrants, and he said, "I'll get them to you." And in Lally world, that's somehow due diligence and a good faith basis to gather evidence, which he, as the prosecutor, is obligated to disclose. And the more he testified, the worse it got. I mean, at one point, he said, "Well, I got kind of a affidavit or something to the effect of a few pages, but an incomplete document." And how do you not follow up and say, "Where are the rest?" How do you not tell the defense attorney, "We're working on this"? He just demonstrated complete indifference and what I call the, trust me, bro defense. Just Proctor says he'll get it to him, and in Lally world, that's sufficient. Of course, it's the absolute opposite of sufficient. It's disgraceful. I don't know how. What became clear to me is he's dragging the DA's office into the 1983 action under a Monell claim, if you will, demonstrating just the complete negligent supervision, lack of training. Because if this is the best they have, or one of them, and this is the way they practice, it's clear they have no system in place to comply with their obligations to make sure that defendants are getting what they're entitled to. And the real conclusion I came away with after watching that, and I've never seen anything like that. I've never seen a prosecutor literally say, "It took me 4 years and I didn't even know there were search warrants, but you talked about him in the grand jury," kind of thing. Was that he's not fit to work there. He really should be let go or leave on his own. And I'm a little surprised that the people running for DA were not really more outspoken about this and saying, "This is something that I'll never tolerate from day one, and people like Adam Lally will be gone." I'm surprised.
Yeah, and so many responses I have to what you said, because I think you brought up so many good points. Number one being, you can't really separate Lally and Morrissey.
Correct.
And at a prosecutor's office, a top guy like Lally that's been there forever, that gets handed the most priority, most important cases, has a direct connection, listens to, trained by, same kind of deal, right? It's kind of like partners in a law firm. We've got to be on the same page. And in that scenario, he's handpicked, he's trained, he's got to do things the way Morrissey doesn't, because sometimes, especially in state DA's office or prosecutor's office, the same prosecutors stay in, even if a new DA or state attorney comes in. Very different in the U.S. attorney's office. They're almost always completely handpicked, completely new line prosecutors. The DA's office, sometimes you can stick around. And unfortunately, like a lot of government jobs, if you've been there for a long time, usually you stick around. But I agree with what you're saying. If you're a new person coming in there, there's no way you can tolerate something like this, because this isn't even a situation where Lally was saying, both of you and I have made arguments as a prosecutor saying they're not entitled to this discovery, judge. We have a hearing. Sometimes we win, sometimes we lose. If we lose, we turn it over. That's not even what most of this is. Adam Lally would agree. Most of this is discoverable, and he still didn't discover it. And it's just pure negligence. Go ahead. What were you going to say?
Yeah, I mean, it's negligence, but without a care in the world. I mean, his attitude and demeanor is one of just complete indifference, and appears to be more of thinking what he's going to do for the rest of the day and what he's going to have for lunch, rather than, I mean, focus on this, or demonstrate any sincerity and purpose to say, "Wow, I was handling this case for 4 years. This happened to my watch." I mean, he recognizes that he's at risk here. I mean, he brought counsel, so he certainly knows that he's a little bit in the soup potentially. Yet when he testified, my recollection is he was asked how much preparation, even reviewing documents, he did, again, to have some intellectual curiosity for justice and to do what's right, which of course is the role of prosecutor. He clearly had none, because I think what he said was, well, I looked at a few things here and there, but he really wasn't troubled to the extent, let me find out what happened here, and let me, even now, even though it's a little late in the game, do the right thing. And the right thing here doesn't mean that this Miles King is innocent. He may very well be a murderer. Based on some of the evidence we heard in the case, that appears not unlikely. But he's still entitled to a fair trial. He was incarcerated. He had to be released in part because of all this delay due to their shenanigans. And if you're going to handle cases like that, you need to do it professionally. And again, he said, I've never had another job as a lawyer. He's been doing this 20 years. Morrissey hasn't had a private sector job in probably 40 years. I mean, you take the two of these guys, and between the two of them, you're talking over 50, 60, 70, whatever, however many years where they have been just bureaucrats entrenched in this Massachusetts trough of public tax money paying for you and a lack of accountability. It really leads you to question and say, maybe it's time for you guys to go and let some new blood in there and let people with a little more seriousness of purpose, a little more intellectual curiosity, and a little more understanding and concern with their professional duties and obligations take over.
Summer's almost over, and we want to squeeze every bit of fun and not waste any time before the school year starts. And Green Chef helps a ton with that. Green Chef makes it easy to spend less time in the kitchen and more time enjoying the last days of summer. They have real, clean ingredients that help you build lasting, healthy habits without the hassle. You can enjoy salads that are ready in less than 5 minutes, protein-filled breakfasts, or nutrient-rich smoothies to fuel your day. I absolutely love a fresh, ice-cold smoothie on a hot summer day here in Florida. They have 80-plus dietitian-approved weekly meal options, and Green Chef makes it easy to find meals that fit your lifestyle. Make this summer your healthiest yet with Green Chef. Head to greenchef.com/50LYK and use code 50LYK to get 50% off your first month, then 20% off for 2 months with free shipping. That's code 50LYK at greenchef.com/50LYK. Yeah, if that was my associate and he went to a hearing like that where he was going to be questioned and he told me that's how he prepared, he'd be fired when he got back. Like, you can't, that's too embarrassing to deal with. And the only way you can save face from that is he no longer works here, because that's not how we do it here.
Right.
But that doesn't happen there, number one. Number two, now that this is all on the record, this has been typed down by a court reporter and is in black and white for anybody to read and use in the future, I can't help but have my mind go to Alan Jackson pulling this transcript while Lally's trying to argue he did do his due diligence, and Hank Brennan is arguing he did do his due diligence on the Sally Port videos, on all the different things, the data, the car data, the cell phone data, whatever it is, all the information. They said they did their due diligence and they didn't get it until it was turned over X, Y, and Z years later, partially turned over, edited with, skipping here and there, inverted, whatever. Pulling this transcript saying, Judge, definitely applies to Adam Lally. There's no way he can ever get around this again. I would say applies to their office, because some of his questions were generally, how do you do things at your office as a supervising ADA? It's like, Judge, this is what they do. This is not due diligence. Legally speaking, this is not due diligence.
One of the biggest travesties of the Karen Reed case, and it's less of a travesty because she was acquitted of anything that's meaningful, but one of the biggest travesties was the judge's frankly incorrect denial of a pretrial hearing, a fact-finding hearing, in furtherance of a defense motion to dismiss for egregious misconduct. And although the prosecution admitted a technical non-disclosure of evidence related to the video, a key element for a dismissal is intent. I mean, you have to have the right to explore whether this was malicious or intentional, which certainly would favor dismissal. And people like Proctor and Lally absolutely should have been forced to testify in that hearing. And you have Lally in the same as the King case giving the same defense, which is, I ask for the evidence. Proctor is once again the guy, and I give you everything that he gives me. and then I fill out a statement, a certificate of compliance, making a representation that I have disclosed all evidence. Now, there are times that a prosecutor can be wrong, but in order to follow the ethical rules, you have to file that certificate of compliance in good faith. And good faith means exercising due diligence to make a sincere effort to ascertain whether I have actually turned over everything. In the King case, he said the same thing. I've given them everything I think they have. That's clearly a false statement. He clearly made no effort to actually get the warrants. He had some degree about them and didn't do it. In Karen's case, when they turned over a small piece of a video that they got from the state police, any sensible prosecutor in Karen's case would have said, well, where's the rest? Where is this video from? The video just happens to be from the Sally Port at the Canton Police Department where they took the so called alleged murder weapon. You'd think that video would be pretty damn important. A reasonable prosecutor then would have looked at all the video that they had and determined, why am I missing the video about the exact time that the car is supposedly in the Sally Port with the cops? That's kind of suspicious. Why is the rest of the video all grainy? Now, there may be valid answers for that, but if that doesn't trigger your due diligence to go and determine and figure out what's going on, I don't know what will. And so when someone like Michael Proctor gets thrown under the bus, just like Lally threw him under the bus in Miles King, perhaps deservedly so, but he, the version in Karen Reed is, well, Proctor had all the Sally Port video, and for lack of a better term, he just kept it in his back pocket and never told anyone for 2 years. And then Lally finds more video they disclosed during trial. How does that not trigger to say, what else is there? Is this everything? And then it comes after the trial that you get the Higgins video. We know about the inverted video. If Lally and Proctor had been forced to testify pre-trial in Karen's case, God knows what that would have led to, both in Karen's case, but imagine if in the King case they had that transcript from Lally and Proctor's testimony at the non-existent pretrial hearing. Lally's testimony in King would be that much more incredible. The pattern of conduct here is becoming clearer and clearer, and that's what I find to be one of the most fascinating things about all of this Lally and Proctor nonsense. Is they really do appear to be pulling the DA's office, like the tractor beam is pulling them into a 1983 suit, which traditionally would be just against the police. But there's such a level of negligence and an apparent lack of training, negligent supervision, negligent everything in the DA's office that I think they're going to get lumped into the 1983 action whenever it comes.
Yeah, and that's the thing that really strikes me about Karen Reed's case, because I like to give people the benefit of the doubt. And I understand judges doing that to a certain extent. This rose to the level where more questions should have been asked. They weren't. And now that they are being asked in the Miles King case, you look back and think about that motion. That was kind of an omnibus motion where they had a million different things in there that were misconduct. But the point is, if prosecutors are burying their head in the sand, purposely not asking questions, purposely not seeking out evidence, purposely not turning over things to the defense because they quote unquote don't have them, that's exactly why we have these rules in place. And judges are supposed to be the gatekeeper in those circumstances. And we never got there in Karen Reed's case. Everybody was given the benefit of the doubt when seemingly it's pretty obvious that what Lally explained in Miles King's situation in that hearing is absolutely not due diligence. I assume it's going to be used in 1983. I also assume it's going to be used if I ever had a case against Adam Lally and he wasn't turning something over and I was filing motions to compel and the judge was ordering him to turn things over and he still wasn't, and he says it doesn't exist, I'm going to quote this transcript from this hearing in my motion saying, Judge, he doesn't ask cops. He doesn't knock on the door. He doesn't track them down. He doesn't force them to give him this information or say they're violating a court order. You could be held in contempt, Mr. Officer, if you don't turn this over. He just doesn't do that. So can you instruct him to do that? I would use this against Lally every chance I got if he didn't turn something over.
Yeah, which I think goes to the next point, which is Lally, as a credible prosecutor, is done. He has no credibility at this point. Anytime that there's an issue that his representations are called into question, he has a terrible track record of just conscious avoidance, willful blindness, indifference, whatever you want to call it. He has this pattern where he just trusts the state troopers, and in many cases, because it's such an incestuous relationship where they that I think you might have this, he is obligated to look into that. He's obligated to speak to the cops, to do things, and he doesn't do it. And he testified on open display for the whole world to see a couple of weeks ago that not only doesn't he do it, he doesn't care. He really, truly doesn't care about the consequences of this, other than perhaps how it might affect him going forward because he had a lawyer there who, tried to have him avoid testifying under oath, avoid having him actually sit in the box and all that sort of thing, which of course was a ridiculous request. Admirable for the lawyer to zealously advocate for his client, but to a neutral observer, ridiculous on its face. But yeah, I don't know how he keeps his job. He's not credible. He's not competent, and the only alternative is it's worse than not competent. Which you really don't want to go down that path and believe it.
Yeah, but as I think about that, as I think about the Miles King case, as I think about Discovery and Karen Reed's case, and when you talk about basically the lethargic manner in which Adam Lally practices as a lawyer, then when we hear about what's going on in Karen Reed now that seemingly they're not giving her her phone and her car back, it's
That's
like,
him too. That's him too.
and that's proactive. That's doing something. That's having some gumption. That's not lethargic. So I don't understand. If you just roll over and you lost and you roll over here and you're like, here's your car and your phone back, that seems like it would, as you say, work in Lally world, but it's not. So how do you explain that if you're Adam Lally?
I don't think you can. And again, you every time you hear something new, you say, "How is this guy employed?" And that leads to other speculative questions. How did this guy with this skill set get entrusted with the first Karen Reed case, essentially all by himself? And you start to think, is there a reason? Perhaps does he fall in line? Does he do things the way the boss wants it to be done? Does he look the other way, as Alan liked to say in that case? Is he the kind of guy they knew that if Proctor told him stand down, I don't have anything, that he'll just go with it and not investigate? I don't know. But when you get to even after she's acquitted and they're holding on to her phones, which there's no reason for that, obviously. Once the phones are imaged, extracted, and they're not real evidence in the case, there's no reason to have them. I mean, we've all had these cases. Not the other case in Massachusetts. We don't have those phones either, but that's another story for another day. But certainly every case I've ever had in New York, unless the phone itself is evidence, if it's stolen property that they need to introduce into evidence and they have fingerprints on it or they need to describe it, it's just a vessel for information.
Data.
There's no reason once it's not extracted to just return it. And then so you start to wonder and you say, why won't they do it? Why are they holding on to these phones? They have no basis to do it. And you start to wonder again because you don't give that office the benefit of the doubt and assume that they're acting in good faith. Why would you? I mean, I hate to talk like that, especially as a former prosecutor, but what have they done to deserve that presumption of normalcy in the way they do things? So the question then becomes, well, why might they be holding it? Are there things on that phone forensically that they don't want the defense to see if they were to get the phones back? Maybe they do their own evaluation of the phone and see some shenanigans that might have occurred with data on the phone. I don't know. Are they holding it because they want to give it to someone else, as has been suggested? There's a civil lawsuit going on. Are they trying to help private parties? Why wouldn't you think that these are legitimate possibilities? Because there's just no reason whatsoever for them to be holding her property that has no evidentiary value, and she was acquitted. The car is slightly trickier, but not that tricky.
Yeah, and especially with the phone when we're talking through this, it I don't know what the heck they're doing. I don't necessarily know that there's something on it they're going to see. Whatever, it could be true, but you're opening yourself up to questions like that when you're acting in the way that they're acting now. You've built your reputation basically in Norfolk County, and this is what people think if you don't give her phone back. In the civil case, that's a joke. That's not a real argument that they could have. The civil attorneys are going to get the entire criminal file. they're going to be able to use every little bit of evidence they want to. I don't know how much they're going to want to use, but they can use every bit of evidence from the criminal case once it gets turned over, once all the red tape is cut through, and all of that becomes discovery and evidence in the civil case if you want to use it. So they're not helping anybody out if that's an excuse for them holding on to it. So what are people supposed to do except try to figure out why are you holding on to the car and the phone?
And not even responding. Again, I mean, I take the representations by the defense counsel at face value, which are, we tried to do this the civilized way, without using the court, which is the right way to do it. I mean, if there's a way to resolve disputes, discovery disputes, property disputes, without begging the court for help, that's always helpful to do it in that manner. But when you're left with the fact that this prosecutor, with all his other problems and all the other stuff going on with him, can't even be troubled to return Karen's lawyer's calls about her property, even if it's just to say, look, file a motion, or it's being held by the state police, or send me a release. We'll send you a release for it. Go get it. The answer that at least I saw in a published article was he just didn't respond, which is another example of his complete indifference, doesn't care, and thinking about what's for lunch rather than his own professional credibility. And it's embarrassing. These things that keep happening in that office, it feels like one giant cartoon, that this can't possibly be real, but it happens again and again with them.
Yeah, this leads me to believe that if Adam Lally would have tried trial number 2 and had the same result as Hank Brennan, he would have asked for jail time at the end for the DUI. That's the type of thing this is, because it's like, this is just something you do. This is not like another battle you win or lose about if you're going to turn her phone back over to her. It's like, that's what I don't really understand about it. But maybe you're right. Maybe it falls perfectly in line with Adam Lally's way of practicing law, and he just hasn't gotten to it yet. In 6 or 10 months from now, he would have gotten to it. But Karen Reed's team is not going to wait that long.
Well, which I don't blame her. I
I
mean, I
don't either.
think, and she has all the leverage, all the momentum, if you will. I'm sure they're going to drop a bomb at some point in the future with a, very sexy federal civil rights claim, which is going to lead to Lally and others being deposed. So they are going to get that crack at him, and they are going to be able to examine him about all that Miles King stuff. And certainly, more than anyone, because you probably do civil depositions every day or close to it. I mean, other than some sorts of privilege objections, it's all fair game. You can object all you want.
Yeah.
It's all videotaped. It's all going to be there, and it's all going to be out there. I mean, he's going to have to answer the questions, is what I mean.
You've never seen a lawyer care less about an objection than at a civil deposition. They're like, "Hey, you done with your objection? All right, go ahead and answer." It's like that's what it is basically every time.
Short of privileged conversations and things of that nature, there's going to be an answer, and it's going to be on video.
Yeah, I mean, we literally just had in a trial that we've got going in less than a month. We just had somebody turn over what they claimed to be privileged text messages that were absolutely not privileged. They were just really bad between their client and other people involved in the case. And so when you get a privileged objection in a civil deposition, like, what specifically is privileged? Let's talk about it. What can I ask? What can I not ask? Because they want to have this broad topic that we can't talk about that most of the time does not at all fall within the privilege. That's a side story. So one of the things I like that you brought up, and something I've been talking about with the Brian Walsh case, is Miles King might not look good for Miles King as far as the evidence against him. Brian Walsh, some could say the same. It's not the same factually as Karen Reed, but when we're talking legally and talking about how prosecutors and law enforcement work, those criminal defendants have the same constitutional rights as Karen Reed, as any one of us if we're accused of a crime. And we saw in Brian Walsh's case a slew of motions to suppress based on alleged wrongdoing of law enforcement and of prosecutors potentially in that case dealing with a lot of the search warrants. And while it was not an overwhelming, huge victory for Brian Walsh and his defense team, they did win multiple motions to suppress based on actions by law enforcement, getting search warrants where there was no probable cause, and evidence was suppressed that was gathered, adding days to another search warrant, which I thought was very interesting and strange, prior to when the crimes were committed, which all the evidence shows is prior to when the crimes are committed. But what did you think about that when you saw the motion, when you saw the names, again, very similar names, and then what parts were suppressed while they weren't huge? It's still impactful with how you look at how a department of officers work, in my opinion.
Yeah, I mean, you start with a case like Brian Walsh. Walsh is guilty as hell. That's not my opinion. I'll go by the evidence, but let's be candid. You know, these Google searches and whatnot. This is bad stuff. So Brian Walsh goes into court and he is fighting, in addition to the Constitution and other things, that most famous and unfortunate rule of law that many lawyers are familiar with in certain cases, and it's called the bad guy rule.
The
Um,
generally bad guy rule is what we call it here.
every state has it.
Mhm.
Um, its precedential value applies to all 50 states, the federal government, and Puerto Rico. Everywhere you go, there is some degree of a bad guy rule. And for those who don't know what it is, under the bad guy rule, judges generally will interpret things in a light any way that may be favorable to not allowing the bad guy to benefit. So I think to some extent, the bad guy rule certainly is in play with Brian Walsh, because this is a case, putting aside the bad guy rule, if ever they should dot I's, cross T's, and just do this properly, this is it. I mean, this guy it appears to be a pretty dangerous psychopath and just cold hearted of his wife and whatnot. And when you see the same cast of characters, they did lose some evidence. I don't think it's going to matter. I mean, the evidence that was admitted pursuant to the bad guy rule is so bad that I think it's going to not be good for him. But the fact that we're even discussing this and that there was a legitimate chance that that evidence could be suppressed, and of course, there's going to be appeals, and even a conviction could be in jeopardy at multiple levels of appeal based on what these guys did. And when you heard some of the testimony in the pretrial hearings about how they interpreted consent to search and how they then changed it to in a light most favorable to them after they went a little too far, and told this story of that a very credible lawyer who gave written consent somehow allegedly agreed to give oral consent to expand it for no discernible reason. Number one, it would be against her common sense practice to do it. And number two, why would you do it? If you're representing the client, you're afraid of what might show up. You just look at the testimony of these guys, and it doesn't make sense. And, I think they did get protected by the bad guy rule on the so called lesser cases, right? These are all high profile, important cases. They're cases. There's no question that they had to have known that Brian Walsh was going to be a big case. These are wealthy people. It's a young, attractive woman, successful, who's in a very wealthy town. I mean, that's clearly going to be something that's going to be on the public radar no matter what. And the way they cut corners and, frankly, do sketchy things, you saw it in Karen's case, and you saw it in all these other ones that I'm sure we'll talk about. What are they doing in the cases that are not on the radar? I mean, I don't think they're saving this for the cases where the light is shining the brightest. And it just leads you back to say, what is going on in this county with the way they do things? Why is every important case feel like the defense has legitimate arguments for misconduct? Again, there are times that the defense has legitimate arguments on guilt or innocence because there are proof problems. But when you get to like Brian Walsh, let's be honest, the argument here, it's a technicality. It's the cops were moving the goalposts and involved in shenanigans. With Miles King, this is all shenanigans and non-disclosure of evidence. We don't even know if any of that evidence is exculpatory or helpful in any way to the defense. I have no idea. Karen's a different situation. That was a demonstrably weak case, which was probably enhanced by shenanigans as well. But it's the same county, it's the same people in all these high-profile cases they're doing, and it makes you wonder how much more of this is really happening.
Yeah, and that's the problem with the Brian Walsh case is it's more evidence that they're willing to grab everything they can, however they can, and if they have to throw a little bit back, that's fine, but you have to realize they're the cops. They're the prosecutors. Everything's going to be looked at in a light most favorable to them. Everybody wants to keep the bad guys off the street. So if they push a little too far, if they get one too many search warrants for one too many cars, if they add 1 or 2 days, Who knows? Maybe you'll have the right judge that will allow all that to come in. And sure, let's go get the guy convicted and let him take his chances in appeal. Nobody wants an overturned guilty verdict. I understand that, but it's much harder to win on appeal than it is during a trial. So that's what this evidence is to me. That's what I got most out of the Walsh case is these are the types of law enforcement officers that would rather ask for forgiveness than ask for permission. They're going to do it their way because they're going to say in their head, this is a bad guy. We've got to get this guy. And I actually, for the viewing public, I love the fact that Karen Reed and Brian Walsh are happening back to back so that people can understand how we as lawyers try to apply laws and constitutional rights equally, whether your case sounds like Karen Reed's before it went to a jury or whether it sounds like Brian Walsh's. Because what happens is they push the envelope and break the rules a little bit in Brian Walsh and everybody applauds, you got the bad guy, but then they're going to do the same thing to Karen Reed. And everybody's going to notice and everybody's going to be pissed off about it. That's why we can't allow it in the Brian Walsh case, just like we can't allow it in the Karen Reed case. And I think it's important for people to recognize that.
Yeah, it definitely, and even the kind of things that you mentioned about, ask for forgiveness later, but do the right thing now. There is evidence of their willingness to do it, and I mean, you saw some of this in Karen's case in some of the text messages, not the ones about calling her all these
Yeah.
horrible names, but these messages about, you couldn't even get a homicide determination from the ME, and I'll go down there and making fun of them and bullying her, for lack of a better term, into classifying a death, a homicide. They're pushing the envelope to get what they need to bring charges and to justify their conduct, and then the consequences be damned later. As you said, who cares? And I think you saw that in some of the testimony in the Walsh hearing about the change in consent. I thought that testimony was absurd on its face. I think it was Buchanan, actually. This is a trained investigator who's, she gave us the right to go deeper and go look. And you say, yeah, are you saying that because it's true? Or are you saying that because you guys extracted the whole phone when you weren't supposed to do that? And you said, oh my God, he's Googling, how to chop up a body, or words to that effect, and all these terrible things. And look, even a scumbag has constitutional rights, and the larger point is they're not always going to be scumbags. So you need to make sure the cops are behaving properly. And in Norfolk County, there's too many of these cases with the cops and prosecutors either together or with the complete indifference or condoning it by the DA, which just makes it not acceptable. And that's why so many people in the public have such a low view of that office and such a mistrust of that unit of the state police. I mean, there's a complete confidence crisis in the Norfolk DA's office. And I mean, I assume it will manifest itself with throwing Morrissey out at some point when there's the election. But, that's over a year away. And it's not good for the public safety. It's not good for the public trust that this kind of relationship between the community in general and the prosecutors and police go on for the better part of a year. Jurors aren't going to tolerate it. The voters certainly aren't going to tolerate it. But you don't want the bad guys as a member of the public to go free because the cops and prosecutors can't act professionally. And, that's the concern that could be happening in Norfolk County with some of these cases.
Yeah, and that's also why, those text messages that did come out, those personal text messages for Proctor are so important. And we never usually get that, although we can tell with certain cops, we've had cases where they've been the investigators on that that's exactly what they think. When they say, we know it was the girl, she's going to catch serious charges. We're not going to even look at the guy in the house because it's a Boston cop. Like everybody can be like, okay, what does that prove? She still could have done it. It's like, okay, that's fine. And even if cops are right with who they think it is at the beginning of the case, good cops cannot possibly run an investigation like that because that opens yourself up to so many problems that manifested themselves throughout Karen Reed's entire investigation and prosecution in the entire case. And now you're left with victims who probably think Karen Reed did it and it was an.
I think, Karen's case is the perfect storm of bad for the DA because there are certain segments of the population who, they may not be constitutional thinkers and say, well, even a scumbag has rights. They take more of the Clint Eastwood and Dirty Harry. I'm all broken up about that man's rights when he was torturing to get a confession in that movie. But the point is, people with that attitude, they look at somebody like Brian Walsh and they say, the guy's a scumbag, he's guilty, it's for the greater good. And that works with some people. It shouldn't, but it does. But the problem they have is that the case that became ground zero for this issue, Karen, many people recognize the case against her was not good anyway. And it's a misconduct case on top of probably an innocence case. Certainly, many people believe that, and they just kind of merged because the cops made it so bad in the sense that they made it a litmus test case because of the taillight fragments. I mean, if the taillight was there from an impact of her car, then you would certainly say, well, the cops, they're clean. Like they didn't frame her, right? If the taillight was there. But if you start to question it, that there wasn't a car accident and there's taillight pieces there, well, then you go to the next step, which is to say, how the hell did that get there? That's disturbing and leads to the next thing and the next thing. And all of a sudden it becomes not just that there's reasonable doubt, but there's corruption here.
Yeah. And again, you mentioned earlier that these are people, especially Walsh and Karen Reed, one way or another, with enough resources to not only fight against it, but to highlight in ways to get people to watch, to get it to be a high profile nature. Um, and then you have Sandra Birchmore, who is not that type of person,
Right.
who does not have that ability, who her family and just her life and her upbringing and the difficulties of everything she went through is the exact type of person that bad cops think that they can pull one over on and almost got away with it, right? And again, we have some of the same officers involved, and this is the height of the evil and what it can become when officers feel like there are no rules.
It's terrible. I mean, you have a young, presumably in her early life, troubled girl who's trying to make herself better by becoming a police explorer, whatever they call it. And, you want them to help you and train you into good habits and responsibility. And instead, they groom you for all kinds of, sexual abuse and statutory rape and other things. And ultimately, I mean, if you think that the Norfolk DA and then the state police and even the local police on some level have the public looking at them with one eyebrow raised based on what happened to Karen Reed, what happened to Brian Walsh, the shenanigans of Miles King. When you take something like Sandra Birchmore, based upon the federal indictment, what the feds are really saying is that these people framed Sandra Birchmore for her own murder. It's terrible. I mean, the allegation here is that a local cop basically staged a suicide to cover up or and the same cast of characters on some level who investigated this, if they weren't directly complicit, they certainly were not diligent in trying to get to the bottom of what happened. They certainly, screwed up the evaluation of some of the electrical data. They, for whatever reason, couldn't figure out, based upon the injuries and what's traditionally, a choking type, by a human being injury with a hyoid bone versus a hanging. And they just seem to miss all these red flags. And it's the same DA's office ultimately. I mean, really, ultimately, it's Morrissey who's responsible for signing off on this. He's not responsible, obviously, for what happened to Sandra
Right.
Birchmore. But I mean, how can anybody have any confidence in these people when you see what the feds had to do and bring in their own medical examiner, all their own investigators, and basically, I don't want to say invent a federal crime, but they really had to dig deep. I mean, to charge Farwell federally, they had to basically deem it the murder of a witness to get like federal jurisdiction. That's how important it was. I'm not saying she wasn't technically a witness, but it's a little far out
Yeah.
there.
Yeah.
But they wanted to make sure that they could do it because they don't trust the state to do it. They don't trust the Norfolk DA. They don't trust the state police. They don't trust the Canton police, the Stoughton police. And these people all know each other. And it's just a terrible, terrible look. And it's the same cast of characters.
Yeah, and that's the problem is we can't have the feds policing our state prosecutors and state law enforcement. It just I realize that that's part of their role and they do it from time to time in their federal investigations, but that's just not what they're set up for. They're not going to do it enough, which is why every single time you have something like a Karen Reed, a Brian Walsh, a Miles King, a Sandra Birchmore, it needs to be highlighted, and it needs to be nipped in the bud. And you can have a bad prosecutor, and that bad prosecutor should get fired. And the higher up prosecutor, the elected prosecutor, should say, we don't have that. We won't have that. We will fix that. If you have a bad cop, I get it. They need to be terminated. They need to be dealt with. It cannot be something that is systemic, which I know can be a buzzword for people. But when you look at how many cases this is touching and how bad it can get, when it gets to the level of everybody is in the trust me, bro business, as you say, and everybody's in the, like Buchanan said, well, if Trooper Proctor wrote it, I take it as gospel. Why? Why would you take it as gospel? I bet Farwell had some people that felt the same way about it, and you get in this brotherhood, and it's like, that's not how the world works.
Some of the materials, on the Birchmore state investigation that were published, they're available online. There's the one where Farwell gets interviewed about some of this, and look how he's interviewed. He's interviewed in his buddy's police vehicle. The report calls him Matt. I mean, is that the crime of the century in terms of how a police report is good or bad? No. But in the context that we're looking at, where this is so incestuous, where everybody knows everyone and they all grew up together and this and that, I mean, how the hell was, Officer Farwell, not Matt, not said, we need to go downtown and talk about this, or wherever they go to do this, as opposed to sit and shoot the breeze in a police car and then talk about Matt and talk about all of these things. I mean, the optics of this investigation, just like all the other ones, it looks terrible. And then you end up with a federal indictment for a witness. And you not only do you lose confidence in the state, but as you know, and some people know, but perhaps not everyone, Matthew Farwell appeared in federal district court about a year ago, and I don't believe he's appeared since. And that never happens. And he has repeatedly waived his federal right to a speedy trial. And federal judges generally don't like to do that unless there are strong reasons. And he has consented to do that, and the judge has blessed it. And it leads you to wonder, why would that be? Why would that be? And you can only surmise that, he's trying to make the best possible arrangement that he can. And what that might include, it doesn't take a genius, is to spill whatever information he may or may not
Good. Right.
about his own case or other goings on, and hope for the best. And for him, could that avoid a death penalty? Clearly. Could it avoid life in prison? Doubtful, but maybe. Maybe it gets him a better window if he gets convicted of this terrible crime. But it'll be very interesting to see what else, if anything else, is going on comes to that. Because for him to get arrested and not appear for a year, I mean, you just don't see that.
And it takes me all the way back to, I don't even remember which officer it was. I don't think he testified in the second Karen Reed trial, but the guy that got in a fight at a gas station and then had charges written up with the guy that he fought with, and then they filed a lawsuit, and it was just like, all that fits just right perfectly into how these cops work. It's like, hey, I got in a fight. I need to, this guy came and he reported me. Okay, let's get charges against him. So he's a criminal defendant. So nobody will believe what he says when he comes and points a finger at me later. Don't write up a report for, I mean, it's dirty. It's bad. And if it's allowed to continue, it becomes Sandra Birchmore.
I think that was Officer Lang,
Yes.
and the brothers, that there was some kind of, and he was helping Chris Albert or one of this cast of characters, and they filed charges against these guys, which I think were ultimately dismissed. And then there were civil settlements. But yeah, I mean, it feels like copland. I mean, that's what it feels like. And these are, and the crazy thing is, these are not the city, obviously. This is not downtown Boston where this is happening, but it's not like Canton and Stoughton and these towns where all these people are coming from and doing things. These are not little towns in rural Mississippi either. I mean, this is suburban Boston, large counties, and the kind of behavior that you're seeing. I mean, it just feels like a culture of corruption. And, corruption doesn't always mean slipping manila envelopes full of cash across the barroom table. Most corruption, if you do this for a living, ferments with close relationships, comfort, just a coziness, and helping people out. And, that's what a lot of people think is happening in Norfolk County. And there's certainly some degree of evidence to warrant that.
Yeah, and it's not like you and I are sitting here sharing, your worst experiences as a prosecutor and criminal defense lawyer in New York and me in Florida and oh, did you hear about this? These are all happening in a too close of a period of time over the
Yeah.
last, if we include length, like last 20, 25 years, all of this stuff happening in this one area. I want to say, okay, this isn't Goodfellas. It's like, and then I keep reading. People keep sending me more stories. I keep looking at more dockets, and it's just mind blowing that it feels like it's as bad as people think.
And it's going to harm the wrong people. I mean, there's going to be a point where, Norfolk juries just don't trust state police cases or Canton police cases or certain prosecutors. So there's a trickle down effect. It also impacts the credibility of the good prosecutors there. I mean,
Right.
it would be unfair to just say everyone in the Norfolk DA's office is a bad apple. That's clearly not
Absolutely.
the case.
Same
I
with
feel,
MSP.
of course, absolutely. I mean, I feel bad for the good prosecutors whose reputations and credibility are being diminished because of, the bad apples and the lazy apples that they have
Mhm.
there.
And if you're a third year assistant district attorney, there's not really much you can do. I mean, I guess you could quit and you could really stand on business, as they say, and then you're out of job and you got to go figure out where am I going to work? And you go apply to Betero and you're like, all I've ever done is work for Morrissey. You don't want him. So it's like you're in a position where it's a very difficult spot for prosecutors that don't have any leverage or weight or decision making power. So we're not throwing everybody in, but you need to, if you are a young prosecutor there, you need to recognize these issues, because if this is how you come up and this is how you learn, I've seen it in some areas in Florida. It starts from the top, and then those people are prosecutors. They prosecute that way. Then they go out and become criminal defense lawyers or judges, and it's the same problems. And those
Mhm.
problems just spread. It's kind of like a coaching tree if people follow sports. It's like you got a Bill Belichick type of coach. He's usually going to be a certain way. And you got Vrabel, and you're like, yeah, he's kind of like Bell, whatever. You have these trees, and they pick up things from who they learn from, for better or for worse. And this stuff can be very far reaching.
Yeah, I appreciate the pro Patriots analysis, the throwing out Vrabel and Belichick. Unfortunately, the Belichick coaching
Not great.
tree historically has not been great because many of them have tried to mimic that
Mhm.
brute style, and it hasn't resonated for the most part. But
Not everybody's got the stones. They don't realize the stones it takes to do things the way you want to do them, and everybody do your job. And I'm going to pick who I want to pick and sign who I want to sign and not pay who I don't want to pay. And the effect you can have on guys like Randy Moss and how they can be the worst player in the world in Oakland and then come somehow be the best receiver in the league. So, I mean, but that's kind of not so untrue with some lawyers, right? Especially some lawyers that become the elected prosecutors. Like they're the best trial lawyer in the world. They do, like, let's just use Alan Jackson for an example. You can't really mimic Alan Jackson if you work for him. And I think that's kind of a testament to Eliza Little. She doesn't really seem to try to mimic Alan Jackson. She's very good at what she does. And I don't know him personally. I know you do, but I'm saying he doesn't seem like the guy who's going to grind away and bleed his eyes reading through case after case. So they need each other. And that's how a lot of law firms are. You work together, you find your strengths, and it doesn't always work trying to be like the person you're learning from. And that can be a lot of people's downfall.
he's pretty hardcore actually in terms of
Yeah,
doing
so I'm
the thing.
wrong. That's just my
Yeah,
guess.
no, no, I'm just saying. I mean, he's not a like hand him the brief and go do your thing kind of guy. He rolls up his sleeves and does the
Awesome.
work. But putting that aside, you're right. I mean, obviously, everyone has to be in their own niche and role, and you can't just mimic someone. And he is the kind of persona, is certainly as a trial lawyer, that's gonna have that alpha personality or just like very out there personality. And if there's
Right.
too much of that, yeah, I mean, that probably isn't a great thing. But
Yeah,
yeah.
I just think that what it really comes down to is starting from the top down. Hopefully, if somebody else gets in there, they either get rid of the bad apples or train them better, because I do think training is a problem. Training is a problem a lot of times in law enforcement offices as well. And if you learn from cops like Proctor, how do you expect them to progress and be anything else? Do you think, what do you think as far as other cases, whether it's King, Walsh, Birchmore, whoever, if Proctor is at all involved, or is this going to become more of a thing, getting some kind of personal text messages? I know it was because of the federal investigation, but now that it's out there, How much do you think we will see those in these other cases? And to me, it's almost more damning if he's also talking similarly about Brian Walsh, for example, because they all acted like Karen Reed was a one off. We don't usually do that. I was just so distraught because it was a fellow officer. How do you think those text messages are going to continue to percolate?
It's going to be a problem. You're going to see, and this speaks more problematically of the Norfolk DA's office than anyone else. But I think what you're going to see in any case coming out of Norfolk County with this cast of characters, part of your pro forma list of things to do is make a TUI demand to the federal government. Right now, that's crazy. The idea that that would be something that you would think about doing in virtually every case. Well, the feds are going to have to buckle up. Those letters are going to be coming. I think it was the Walsh hearing, some of the stuff you even saw a week or so ago. The other prosecutor on Karen's case, McLaughlin, made reference to some kind of exculpatory information that I'm not allowed to disclose. And well, that I understand they're hiding behind well, that's not even fair. The federal order is what the federal order is. But if
Mm-hmm.
there's exculpatory information, that damn well better make its way to the defense, whether it's they have to figure that out. But the suggestion there is that's got nothing to do with Karen Reed. That's how I interpreted it. That there are other cases where Proctor may have said things that are deemed exculpatory, whether it be his lack of discipline with the evidence, or even just as it relates to his credibility, because he said God knows what about anything like that. I mean, I've always wondered. There's no evidence of this that's been public, and I have no knowledge. But I mean, if he was talking that way about Karen so cavalierly about looking for nudes and doing things like that, what might he be doing about Anna Walsh? I
Yeah.
mean, Anna Walsh was a relatively young, attractive married woman, and they're presumably looking through everybody's stuff. And why wouldn't you think he might do that and talk about it? I don't know. Maybe if I'm wrong, I'm wrong. I don't have any knowledge of that. But what are they holding back? Whether it be the feds or the state. And I do think that's going to be the impact. Everyone is going to focus on this. They're going to make Proctor and the rest of these guys an issue in every case. And there may very well be a basis where judges are going to have to allow it. Um, there are things that Proctor has done in other cases that are questionable. There are, you heard a client in another case make reference to that about some things that are under impoundment that can't be talked about. So they can't be talked about. But when at some point when they become unimpounded, you might say, what is this guy doing? I mean, what else is this guy capable of? We'll see. But
Yeah.
I mean, I think you're going to see also post conviction work. I mean, I've done many post conviction investigations, and if I was a regular Massachusetts practitioner and people were coming to you about I was convicted in a case in which Proctor was the lead investigator, I mean, that's probably worth looking into if the guy has a legitimate story of why he thinks there's something there. There's so much more work that's going to have to be done on that county, and there's so much bad credibility and a lack of credibility and respect that they're going to be given coming out of the box. I mean, the system, in order to function properly, has to work where you presumptively that prosecutors and cops act with integrity and are professional and due diligence and in good faith. What I'm suggesting is based on the cases that we're talking about now, as a lawyer, as a juror, as a voter, as a taxpayer, as a resident, are you willing to give them that benefit? I don't think so, not without doing your own due diligence. And that's a terrible thing to say, but I think the evidence warrants that.
Yeah, and that's the worst case scenario is they screw up so bad that somebody that is deplorable, despicable, horrible, evil, killer, whatever you want to call it, goes free because of their bad police work or their prosecutorial misconduct. Which, by the way, if it rises to that level, that person absolutely should go free. Which is why we've got to nip it in the bud.
But take the King case, perfect example. Again, these search warrants, no clue whether they have anything that the defense in good faith could argue, oh my God, if I had known this, I could have done that. It could impact the case. But assume there isn't. Assume they're just garden variety search warrants. based on legitimate probable cause that led to legitimately seized evidence, but they established that it was for whatever reason intentionally withheld for whatever reason. That can lead to a dismissal in Massachusetts of an indictment of somebody who is a stone cold killer, and the evidence fully supports that because some knucklehead cop and or prosecutor just couldn't get off their rear end and turn over the evidence for whatever reason. And Proctor's going to have to testify in that hearing, and although Lally's the one with the ethical obligation and he's got his own legal exposure perhaps to deal with this, Lally, in essence, has blamed it all on Proctor. So, what happens at this hearing if Proctor tries to claim some version of the fifth or says, he never asked me, and there's an inconsistency between two witnesses, neither one of whom is particularly credible? I mean, I don't think a judge at that point has any choice other than to say, I don't find either one of them credible. Something's going on here. I find this intentional. Dismissed unless there's something we're missing.
That's the end result that should scare everyone. And that's the problem. And then how many of those are there going to be? Because usually it's a domino effect. Once the jury did the right thing, but now that we're continuing on where it might not always be the same situation, the same problems exist. And that's the big that's what you want to avoid and what you have to avoid as law enforcement and as prosecutors. And that's why doing things the right way, doing things above board, turning over what you need to turn over, be confident in your case, only charge cases you know that you're going to win, then that eliminates all of the fear and the problems that were there in Karen Reed's case.
Yeah, do justice. It's not, as a prosecutor, it's not a difficult concept. It can oftentimes be difficult to do based on evidence and what you want to happen with the result. But if you have as your compass, your guidance, just do justice and do what's right. As a prosecutor, you can go home every day, kick your legs up, and be satisfied that you did what you're supposed to do. You're seeing in too many cases in that county, it doesn't look like that's the case.
Yeah, and I know the case that, we're not going to talk about today for obvious reasons. The same thing, the same cloak is over that case. The same cloud is over that case, and you as a lawyer have to consider what's important, what's not, how you shine a light on it, how you don't, where you pick and prod and where you don't. And each lawyer is going to have to decide that individually in their cases, but we're not alone in looking at this area and it just stinks. Like that's the point. Anything you uncover, every layer you peel back, it gets worse and worse. And I don't know if it feels like we're more at the beginning of it than we are at the end because a lot of the things are being brought into the light now. And like you said, there's a year before any elections. I think a lot's going to happen between now and then.
It's very stunning because if you had told me a year ago, or maybe a little more than a year ago, before I even learned about Karen's case and other things and led to all this other stuff, if you had said to me within several months or a year, Norfolk County, Massachusetts, will be the national poster child and laughing stock for fundamental fairness in a criminal proceeding, that's the perception. Again, I would have said you're crazy. There's no way. Massachusetts is an intelligent place. It's a sophisticated place. It's also a very liberal place. That's not a political statement as much as you would think that it would be, very cognizant of a defendant's rights and fundamental fairness and all of that. It's just shocking to me, though, that you would say that the largest public confidence or crisis in public confidence in any particular DA's office in the country, perhaps, would be Norfolk County, Massachusetts. I just would have thought that was absolutely insane. And here we are a year later, and there are so many prominent national commentators like yourself and others with like national platforms where you pick and choose and can dive into any case in any place in America. And there is this gravitation towards case after case after case in Norfolk County, Massachusetts, because there's obviously a reason something's going on and people are interested in it. And that's shocking to me.
I agree. And I think that the one good thing is a lot of people there that can vote and can make a difference with what they do, how they live. It's their taxpayer dollars. If it was just one case, maybe they'd be like, but I think most people are seeing what's happening there. And the only comment I'll make is another indication, just like hey, cover for me. We need to file these charges if you're Lank. We need to cover this up. We need to, extend this search warrant a little bit longer, change the dates. Let's get the car because we can. Using witness intimidation statutes, whether technically you can make the words fit a certain way as a lawyer, um, to try and help your case, putting people on witness lists to try and keep them out of the courtroom, trying to affect people's right of free speech and affect the press, and gag orders. And that all is usually something that follows when there are these problems in these locations. I mean, that to me, and it's the same thing. I mean, I don't know if you've looked at this Aaron Spencer case. I just started looking into it in Arkansas. Gag order day one. And it's like, that's weird. And it was overbroad, and the Arkansas Supreme Court ends up shutting it down and lifting the gag order. It's like, that's usually not a vote of confidence in your prosecutors and in your judicial system and letting people be a part of the legal system that they pay for.
Yeah, no, that's a really good point. I mean, you see in these cases, no question, and I'm talking beyond my own case,
Right.
the weaponization of the witness intimidation statute, what some people would call lawfare. Going after guys who toss a few rubber ducks here and there, or people that hold signs, they protest. So what do? You silence the critics because we're getting publicly ridiculed for the way we're handling this one case. In every state, legal proceedings are presumptively open. The public has a presumptive right to open access. You've seen in a lot of these recent Massachusetts cases that there appears to be, from the prosecution's perspective, a presumption of impoundment to deny the public access and then make you work backwards to show why it should be. Now, that's ass backwards. That's the exact opposite of how this should go. As you noted, using a witness list as another form of lawfare to keep journalists or people out of the courtroom and do things like that. You don't do that when you're trying a case and you have confidence and you believe what you're doing is right. If you have the evidence, if you have the goods, you go to court, you present them, the jury follows you to the finish line. This other stuff, these are major red flags of shenanigans and other things that show a complete lack of confidence in what they're doing and obsession in trying to get a result, which is never what a prosecutor should do. You can't focus on the result and then figure out the means later. You have to do it the right way to get the result you want. And if you do that, congratulations, that's how prosecution is supposed to work.
Yeah. Yeah. And again, like I said, I think Karen Reed might have been the first domino, not the last. I think there's still a lot to be learned and highlighted. And it seems like people around the country and even around the world continue to be interested in what's going on there. So I appreciate you coming on, hanging out for a while, digging into this stuff, explaining what you think, and making sure I always like to test my vibes that I'm getting from these cases, but it just seems like way more than a one-off, way more than a coincidence to me. And I'm interested to see how the truth keeps coming out and what we can do to fix it. Even those of us that don't live there, that aren't taxpayers there, we can do our part in trying to make the judicial system across the country the way that it should be, and continuing to educate people and talk to people about this and get their input. So I really appreciate you coming on with me, as always.
Okay. Talk to you soon.
All right. Well, that's all we got. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.